Good evening, everyone. This is Sheila Zarekari from Just Local Homes here at Keller Williams. Today, we have a special guest, which is Attorney Mika Domingo. We will be discussing estate planning and a few of the questions that actually are common to our own community. Michelle Mika Domingo is the award winning founder and managing attorney of MS Domingo Law Group. With a passion for helping others, Mika Domingo represents people throughout California po in matters involving probate and trust administration, including litigation, estate planning, and conservatorship. Mika fulfills her commitment to fairness, legitimacy, and equality within the legal community by serving on numerous boards, including as the first Filipina president of California Women's Lawyers, as the director of the California Asian Pacific American Bar Association, and as co-director of professional development of the Filipino Bar Association of Northern California. Mika believes that the justice system should work for the benefit of everyone and not just for the few. Mika fulfills these same commitments to her clients by implementing a client centered approach, meaning she places herself in the shoes of those whom she represents. Because the stress and the anxiety of pending litigation can cause barriers to communication, empathizing with her clients can overcome that barrier and contribute to a greater success in the litigation process, treating the client as a person and not just another case. Mika's advocacy for diversity and inclusion has earned her numerous awards po, including the Minority Bar Coalition Unity Award, Contra Costa County Bar Association's Diversity Award for the past 6 years, and the Justice Marciano Inn of Court Award and the California Bar Foundation Award. So, ladies and gentlemen, without further ado, let us welcome Attorney Mika Domingo.
Good evening po. Kamusta po kayong lahat?
So ngayon po, it will just be a conversation. Wala po kaming slides. It would be a matter of kung sino po yung may tanong, yun po ang ating gagawin at sasagutin as we're doing the conversation. So ang first question po natin is, ano daw ang difference ng will sa trust and kailan ba kailangan yung isa't isa? Kailangan po ba yon when we're planning for our estate?
Yes, that's a very good question. Oftentimes people ask, bakit hindi pwedeng isa na lang? So it's important to note that a will and a trust, they're two different documents. Yung pong will, yung last will and testament tinatawag natin, effective po yun upon death, di ba? And yung trust, it's effective now pagka in-execute na, pag sinign nyo na yung document. So there are things you can do in the will and there are things you can do in a trust. Kaya talagang iba talaga depending on your situation. Halimbawa, dun po sa will, you can state your direct wishes, yung para sa personal property nyo, tsaka yung assets. You can also name a guardian to care for any of your minor children. Without a will, the court will decide who can settle and raise your children, right? The state may step in to decide who your assets get distributed to, whether or not the choices match your wishes. As for a trust, as I mentioned, it's effective when you sign in the same way as you can indicate who you want to receive what in a trust. You can only distribute to your children what you own. And in a trust, you have the flexibility. While you're alive, you can take things in and out of a trust. When is a good time to have a trust and a will? if you're over 18 years old, you're really going to need at least a will. Why? Because you can benefit from making a decision on what happens to what you have. If you are a homeowner, this is one of the things that is key. If you own real estate and you want your loved ones to avoid probate, and you want your minor children or adults, of course, to be prepared to manage their inheritance, you want to place something in your real estate, real property in your trust. Why? Kasi po, this is one of the things that you will ask yourself. On the date of death, what do you own? Right? That is only in your name. In California, on the date of death, if you own property in your name and that property is not in a trust and the value of that property exceeds 184,500 in California, your estate is going to go into probate. So, kaya po sinabi ko kanina, kung meron kayong bahay, it's best na ilagay na sa trust. Kasi more than likely, ang value ng bahay nyo, it's gonna exceed the threshold, di ba po? It's gonna exceed 184,500. So, some people ask, is it okay sa will na lang sabihin kung kanino mapupunta yung bahay? Di ba? You can say in your will, I give my house to so-and-so. But what happens is that property did not make it into your trust. Yung sa grant deed nyo po, nakalagay rin yung pangalan nyo po, on your date of death, it's not in a trust. They kailangan din i-probate. So that's why it's important to look at what you own, and if it makes sense, if you think you're going to exceed the threshold, na it makes sense to create a trust and place your property in a trust, that would be the best way to protect your assets and to make sure that your children and loved ones receive what you have. It's not if you don't do so, then what is the disadvantage of not doing that? Well, you will run into probate, and probate is a very public, very expensive legal process. But now your loved ones will have to get through that. And I do practice probate law, but I always tell my clients, you're doing the right thing by placing things in a trust so that your children and loved ones don't have to deal with probate later on when you pass.
So, Attorney Mika, may tanong. Ang tanong is, if may kasulatan nga sila, pwede bang i-notarize na lang?
So, ang kasulatan ba, it's on a general piece of document na nakalagay yung wishes nyo? Ganun ba? Ang kasulatan?
Hindi nila sinabi. Baka nakatype naman. No?
Nakatype
Pero
naman.
tinatanong nila, will that be enough to prevent probate for them? Kung may typewritten na document.
Yes, so hindi talaga pwede kasi ang dapat nating tingnan yung grant deed, 'di ba? Halimbawa, meron ngang kasulatan na nakalagay, itong bahay na to dapat mapunta kung kanino. Pero yung grant deed nyo po, nasa pangalan nyo pa rin, wala sa trust, magpo-probate pa rin no matter what. Or halimbawa may sitwasyon na you want to treat yung kasulatan as a will. So sa California, meron tayong tinatawag na holographic will. So halimbawa naman wala kayong worry sa threshold, meron kayong mga gamit na gusto yung ibigay for specific people and you don't want to have a will made, you can take advantage of the holographic will, the law surrounding that in California. Pwede nyo po talagang sulatan. Kaya lang, kailangan in your own handwriting, yung material provisions ng trust, nakalagay doon kung sino kayo, sino yung gusto nyong bigyan, sign nyo lang. You don't need to notarize, you don't need a witness. But in California po, pagka meron tayong will, typewritten yun talaga. Tapos, kailangan po natin ng either in-notarize or dalawang witness for validity.
Okay. May tanong din na paano kung yung may-ari ng estate is losing their marbles already. Halimbawa, in the early stages of dementia or Alzheimer, ano yung pwedeng gawin ng family to prepare for that?
So, ang tao pagka meron na pong dementia, they are not legally, they cannot legally sign anything, di ba? So, pagka may will na or may trust na, those documents were executed before the diagnosis, pwede pa yun. Diba? Pwede pang valid talaga yung will upon death and the trust upon execution. Ang mangyayari pag may diagnosis na, hindi na talaga pwedeng i-amend yung trust. So, one of the things that can help you para merong clear indication, merong documentation na may dementia, kailangan talaga you need that diagnosis and you need to make sure you have the paperwork to show that on such and such date, yung parent nyo na diagnosed ng dementia. Para halimbawa, mamaya, the date after that, merong nagbago dun sa mga documents niya, matatrace mo yon na hindi talaga pwede. How could your parent have changed something in the will, right, in a codicil to the will or an amendment to a trust 2 years after ng diagnosis? That oftentimes happens kasi po kami po, meron talaga kaming mga kaso sa litigation na pumupunta sila sa amin kasi tinatanong, paano nangyari to na na-disinherit kami 2 years after na naka-dementia, nag-diagnosis na si mommy. Valid ba to? Siyempre hindi, right? So may allegation na changes were made, merong influence, siguro yung parent nyo nag-sign siya, not knowing, you can bring that to court and invalidate that document.
So may tanong din, if they did their trust dito sa California, would they need to repeat the process in the Philippines or from their originating country just to make sure that probably yung relatives sa Pilipinas or in the originating country would still be covered?
So, unfortunately, a trust that's created in California is not applicable in the Philippines because you can't apply California law in the Philippines. So my recommendation always is to consult with an attorney in the Philippines and have the attorney review the trust that you created here. It happens a lot where we have clients who own properties in the Philippines or in other states or elsewhere. In your California trust, pwede tayong maglagay doon ng catch-all phrase na, or maybe it doesn't have to be catch-all, it can specify yung property nyo outside of California. You're saying that I own this property goes to somebody. So when you record yung instrument, usually yung trust transfer deed, i-record nyo doon sa kung saan yung property nakalagay, di ba? Kung sa Pilipinas, doon kung sa Denver i-record. Pero ang advantage ng lalagay mo yung catch-all phrase is that it's showing your intent, right? You intend kahit itong property na wala dito sa California na dapat ibigay kung kanino man, right? So, one of the things we've done, if you're living in California, meron kayong mga bahay sa ibang bansa, we have been able to help our clients to show intent and to allow other countries to at least look at the trust created here and consider that and use that as a guide. So many of you might be familiar, kailangan i-apostille, di ba? Dito yung dokumento. So kailangan nating for anybody outside of California to look at the document that's created in California, you have to get the apostille. So it's easy to do. You have to do it here through the Secretary of State, and we can help you with that kung kailangan yung ganon para maprotektahan niyo yung property niyo outside of California.
Okay. So, isa pang tanong is a common scenario for families, immigrant families, including Filipino communities, is that when they're buying a house, they actually invite other members of the family to be part of the purchase, maybe to qualify for the loan or also to split the cost of owning a home. So,
Mhm.
the question is, how would you protect the estate when there are many people involved in a particular purchase of a home, for example? And I'm sure because this is California, halimbawa, even if there's three or four of them sharing the cost of the house, most of those would be beyond the 184,500 threshold. So,
Mhm.
what would be
Yes.
your advice to those families na nag-share ng purchase of a home or estate, no?
Nag-share ng purchase tapos yung bang sitwasyon nasa pangalan yung loan ng more than two or three people, pero
Correct.
yung
And deed minsan just because it is an immediate, like it's an immediate question, and they would say maybe tenants in common lahat, no, but actually one is a daughter, maybe one is a dad, and then the other one is a cousin or an uncle. So not necessarily within one family unit. And also paano may kapatid pa siguro, pero paano pag namatay si daddy, ano yung kailangan nilang gawin, or paano kung how do they protect themselves bago mamatay si daddy or si mommy. Yan.
so halimbawa yung if yung lahat ng taong nasa loan, lahat din sila nasa grant deed, then first
Oo.
step yon, okay lang, right? But not
Mm-mm.
complete, di ba? Kasi you
Correct.
want equality, equity, right? So halimbawa, apat sila, 25% each. Dapat talaga sa grant deed at the very least nakalagay 25% ownership for each person. Pero like you said, kung yung 25% ownership dun sa house, it's gonna exceed 184,500, tapos hindi nyo nilagay sa trust nyo yun, talagang magkakaproblema mamaya, magpo-probate pa rin. Kaya halimbawa, if you are a one-quarter owner, nakalagay dun sa grant deed nyo, tenant in common, ilagay nyo na sa trust yon. You create your trust
Pwede
in
bang
your...
isang tao maglagay sa trust, or paano, kasi halimbawa tatlo sila, apat sila dun sa purchase,
Yes. So,
saan ilalagay, kaninong trust ilalagay yung property?
isa-isa kayo doon. Kasi yung trust,
Isa-isa, apat
apat talaga. Kasi
or
you can
tatlo?
only put what you own in your own trust.
Okay, all right.
Yeah,
Okay,
that
that's
would be the
good
best.
advice. Tapos may another one, another common situation is one of the parents pass away, for example, and maybe the property has moved or transferred to the surviving spouse, pero um, may bagong PYT si daddy or si mommy, pretty young
Mhm.
thing, may bagong
Mhm.
kasama. How can the family move to protect the remaining estate? No?
So, ang sitwasyon natin, yung bahay, kasi it used to be usually joint tenancy with right of survivorship, right? So, the first
Mhm.
spouse dies, it transfers over to the surviving spouse. And then the surviving parent has a friend, right? And you're worried
Correct.
na baka, well, first of all, kung yung bagong kaibigan niya, they're not married, wala naman talaga siyang say doon sa
Habol na.
property.
Oo.
Walang
Mm-mm.
habol. Pero halimbawa, may domestic partnership, meron din protection siya. Sa California, meron sing community property protection. Pero kung yung relationship hindi pa na solidify, wala pang formal, walang marriage or domestic partnership, kanya lang yon, we have to go to the same principle, right? Kung namatay siya, yung bahay na yon wala sa trust, then ma-probate, then one of the things you can do kung pwede siyang makausap, I mean, you're not supposed to influence in that way, but maybe you can have uh, your parent can talk to an
Conversation.
attorney, yeah, and encourage and provide the information and place that house in a trust. Edition yung sa trust, presumably yung beneficiaries yung mga anak, dapat nakalagay na doon. But there is nothing in the law that requires your parent to give you anything, 'di ba?
Mhm.
Kahit na yung bahay na yon, you might say bahay talaga nila yon ng mommy and daddy nyo. Namatay yung isa tapos yung natitira, does not need to put it to give you a percentage of that in the trust. Kaya nga dapat po gawin na yung trust pag buhay pa yung parents, because they
Mhm.
can really dictate what happens to that house. Parang too late. It's not totally too late pag isa pa lang yung mamatay, but it makes it more difficult para maprotektahan yung bahay, di ba? Kasi he could very well, or she or they could very well say in the new trust, I give everything to my friend.
Correct, correct. So
There's no, yeah,
there's no law to avoid that, no?
yes, yes.
Okay. So it's really about making sure na nag-uusap-usap yung pamilya and making sure that I guess their opinions are heard but not necessarily protected kasi the surviving parent has the option of where to leave the estate, essentially.
Yes, that's their intent. They can do whatever
Now,
they want.
what if the surviving parent marries the new friend? How does that change the scenario?
So pagka marriage takes place, right? So we live in a community property state. So property acquired during marriage is presumptively community property. Eh, yung bahay ba, separate property yun, di ba? Kasi na-acquire yun before marriage. So, most of it, I'm gonna explain why I say most of it, na separate property nung surviving spouse can do whatever they want with it. But in family law, meron tayong law doon na binibigyan din ng uh, kina-calculate then from the time of marriage kung halimbawa yung bagong asawa nag-contribute sa mortgage ng bahay,
Mhm.
nag-contribute sa property tax, meron silang tinatawag sa family law na more Marsden calculation. So, ang gagawin, i-calculate how much did this person contribute and how much did the value of that property increase. Kaya meron din siyang habol kahit na yung
Habol
property,
din.
that separate property, meron din siyang tinatawag natin credit for making those payments.
Okay. Well, may isa pang common question, Attorney Domingo. People are asking, magkano ba or how much will it take to establish a trust with the help of a professional lawyer like you? What
Yes,
should
so
they?
what
Mhm.
should they expect? So I encourage you to call the offices of the lawyers you're interested in, because as for our firm, we do offer a flat fee na ang advantage nun kahit marami kayong tanong, okay lang. Tawagan nyo
Sure.
kami. Pero syempre po, yung sitwasyon nyo next to compared to the next person, hindi naman pareho, di ba? So, we take our time to talk to you so that we can assess kung gaano ka-complicated yung sitwasyon. And then we provide po ang flat fee namin.
Okay. And iba-iba yun syempre, no? Depende on how difficult it is.
Yeah, opo. Tsaka minsan may mga blended families. Tsaka syempre pagka gumagawa tayo ng trust, kailangan ilagay yung property sa trust. How about may mga investment, may mga accounts na hindi payable on debt, kailangan ita-transfer. O minsan yung distribution scheme medyo complicated. So it's gonna depend po yung situation. And it's a case by case. And we make sure that we represent your intent as accurately as possible.
Okay. Anything else from our audience today? I wanted to see kung meron pang mga tanong. Well, at this point, wala na pong tanong. So, maraming salamat for tuning in and listening to us on our YouTube channel. I see that we may have some technical difficulties on our Facebook channels, pero wag po kayong mag-alala because we will post the video and the conversation on our Facebook channels, pati rin Instagram po. And you can ask your questions that way. And for those of you who would like to reach out to Attorney Domingo, let me flash some information from Attorney Domingo. And let me just mag-share screen lang po ako. And I guess ito. Ayan, mag-share screen lang ako konti. So, eto po tayo. And ito po ang contact detail ni Attorney Domingo and the areas that she covers. No, meron po siyang office in Walnut Creek, and you can go and try to schedule for a consult. You can call her at 925-891-5006. Ngayon, with that po, balik tayo sa ating broadcast. There you go. With that, we wanted to thank you again and come join us for our next streaming live. Ang next topic po natin is paano ba bumili ng investment property sa Hawaii? Kasi alam ko marami pong mga Pinoy na maraming kamag-anak din sa Hawaii at nag-iisip na mag-retire sa Hawaii. So stay tuned po for that next streaming. Okay? Have a good night. Marami pong salamat.
Thank you po. Thank you, Sheila.
Salamat, Mika. Alright.